So, in this section of our course, we have been exploring the question, how does one acquire property? How do you get property? And first, we explored what can be called original acquisition of property. How does property begin? This is the idea of acquiring property where either there was none, or as we saw with Johnson versus McIntosh, where whatever was already existing was not recognized as such. The second path in this exploration of how you acquire property asks how one gets property that already exists or is already recognized as property. If I were to ask you, how did you get that device on which you're watching this video? You would probably respond that purchase, you bought it. And purchase is probably the most common form of property acquisition today. There are lots of laws that are associated with different types of sales and purchases. The Uniform Commercial Code is a model law that governs most commercial transactions, which deal with personal property. Securities regulations are federal and state laws that govern certain types of investment interests like stocks and bonds. Consumer protection law is the federal and state law that can protect against unfair, fraudulent, and abusive practices in sales. And through, there are entire courses on these topics, and so we're not going to focus our attention on those topics, and instead we've been looking at some other common ways to get property in the second instance. And a subtext of much of our discussion up to this point, both in the theoretical readings and our cases, has really been the role of government in determining what property is and who has it, right? Think back. Madison, Bentham, Waldron all recognized the importance of positive law. Now, let's just make it clear. Positive law is not law with a happy disposition, law that smiles. No, positive law are the legal rules that are determined and observed by government. Okay? And the subtext has been the importance of positive law, right? And as one of your classmates pointed out, the core holding of the antelope, the determination of whether slaves were property, depended on the law of the competing countries. That's a positive law question. That's a question that makes clear the role of government in creating and distributing property. But government can play an even more active role, right? We have already seen this as well. How did McIntosh get his land? But we can get even more active than that. And that is what we observed with, for example, the Homestead Act of 1862. And I repeat and remind everyone just how important and long-standing this law was. It was not repealed until 1976. Now, what are the requirements of the Homestead Act? Look at the Homestead Act. It's available to you. Even if you weren't assigned to read it particularly, you can still see this on the course webpage. You had to be over 21, you had to be a head of a household or a veteran, and your purpose for acquiring the land had to be actual settlement. You had to want to live there. The spaces were 160 acres, a 1/4 section, and then you had to live there for 5 years. And who could engage in this? Who could become an owner of land via the Homestead Act? Qualified settlers included women, included immigrants, as long as those immigrants were intending citizenship. You did not have to have any special status. You just had to want to be a citizen of the United States. And freedmen, and for those of us who don't know, freedmen are people who were enslaved who had been freed through whatever process. Now, 5 years of residence, and you get the land. If you pay what was $1.25 per acre, you could reduce that 5-year period of residence. Now, then I asked you to think about what justification of property best supports the idea of the Homestead Act. that allowed us to populate 500 million, or to distribute, 500 million acres of land. Well, you can figure out and think through lots of different justifications of property that would lead the government to do this. But I want you to know that it actually turned out to take 20 years to get the Homestead Act of 1862 passed. So that means the conversation began in the 1840s, right? And it was contentious on both sides. The North objected. The South, or Southerners, worried that the new Westerners would compete with their slave-based economy, right, like those pesky Kansans, and support the abolitionist movement, right? But it was eventually passed, and so you want to think, what goals were really animating this choice? And were those goals fulfilled when, as I have mentioned, only about 80 million of that land, of the 500 million acres, went to residential farmers? Instead, speculators, railroads, and other big business got the land, but that project created the physical contours of what you see in the United States today, right? We also read the Emancipation Proclamation, right? Emancipation Proclamation, it's a little bit harder to understand why that would be included on the list of really active ways that the government can give property in this second instance, right? And we're going to return later to the question of whether the Emancipation Proclamation was a deprivation of property by the government. But why would it be seen as a grant of property by the government? Well, that takes us back to cases like the Antelope, where the Supreme Court determined that slaves were indeed chattel. Slaves could indeed be property. Well, the process of the Emancipation Proclamation then would have transferred that property interest that those slaves had in themselves, that was vested in their slave owner, back to the slave, and therefore we could see that as a grant of property, right? 40 acres and a mule, or Sherman's Field order, was much more clearly a grant of property. But again, we want to revisit what theory of property would have supported the distribution of plantation owners' land in the way Sherman's Field order thought to do. And then you got to ask a question. Sherman notoriously, and it's very well documented, that Sherman had a negative view of Black Americans, right? He was not an individual who believed in any sense in the equality of these slaves with free white Americans. And so the question becomes, why would he engage in this behavior, right? He presumably thought that there weren't a lot of other options. And so that leads us to ask, what other options did the government have at the end of the Civil War, when slavery was no longer going to be legal? But we think through those things to understand, one, why the acts came into being, why the government took the action it did, to determine whether or not those rules and those decisions were fair, unfair, just, unjust. Who did they benefit? Have they hurt? And if they did hurt, who did they hurt? And were they worth it? But ultimately, what do we take home? Ultimately, what do we know from thinking about this? It should be clear at this point. The law makes choices. The law makes choices, and we can create entire regimes of law that differentiate between or ignore entire groups of people, or create hierarchies of property rights. And those choices have really long-lasting effects, right? When Sherman's Field Order was rolled back, what it was replaced with was a feudal system of land cultivation in the South, known as sharecropping. And sharecropping in that system retained much of the features of the South's pre-Civil War economy and reinstituted antebellum property alignments that really persisted for generations, not just decades, for generations. And they continue to have influence today, right? In the same way that the transfers of land and the capacities to own land that are reflected in and perpetuated through Johnson versus McIntosh continues to be seen in the way Indian tribes have to litigate their land rights and the scope of those rights and their authority on their land, right? As well as the way the Homestead Act created fortunes for some, even while purportedly being accessible to everyone. Government grants of property are a big deal. It's a huge part of how we can and should understand this area of the law.